What happens when someone calls the police on you? That's what we're talking about today. Let's go.
She did not call the police on him. He called the police on her. He said she was acting erratically. He said she had been drinking. He said he was worried about her safety. She answered the door. Within 4 minutes, she was in handcuffs on her own porch. He was standing in her driveway watching. And because she said 3 sentences to the officers before she understood what was happening, those sentences became the foundation of a case against her that took 14 months and $12,000 to close. She did not get those 14 months back. She did not get that money back. And the person who called, he was never questioned. Here's the thing nobody tells you about police arriving at your door because someone called on you. You probably assume the officers are there to figure out what actually happened. You probably assume that if you are calm, cooperative, and honest, that works in your favor. You probably assume the person who called the one who set this in motion is the one under scrutiny. Every single one of those assumptions is wrong, and the gap between what you assume and what is actually happening in that moment is exactly where lives get derailed. Think about the last time you had a disagreement with a neighbor, a loud argument with someone you live with, a moment where someone nearby decided they did not like what they were seeing. Any of those people could pick up a phone right now, and if they do, what happens next has almost nothing to do with what actually happened. It has everything to do with what you say in the next 60 seconds after you open that door. Let's go through exactly how this works, because the law here does not behave the way you think it does. The first thing you need to understand is what police are legally allowed to do the moment they arrive before you say a single word. Most people believe officers need a warrant to enter their home. That is true. Most people also believe that if no crime has been committed, police cannot detain them. That is much less true than it sounds. Under Terry v. Ohio, decided by the Supreme Court in 1968, an officer who has reasonable articulable suspicion, not probable cause, not evidence, just a specific articulable reason, can stop you, detain you briefly, and pat you down. If police are called because someone reported a disturbance at your address, that call itself is often enough to establish reasonable suspicion. You are now being detained before you have said one word, before you have done anything wrong. This is not a minor legal technicality. This is the entire architecture of what happens next. A man in Phoenix 2019 called police on his neighbor after a loud argument next door. Officers arrived. The neighbor opened his door, said everything is fine, and tried to close it. The officers said they needed to verify that the other residents of the home were safe. That is called a welfare check entry. The homeowner said fine, come in. In the living room, there was a legally owned firearm on a table. The owner had a valid permit. He said so immediately because he assumed being honest and cooperative was the right move. He told them exactly where the permit paperwork was. He answered every question they had. He was charged with a separate unrelated violation the officers noticed while they were in the home, something that would never have been visible from outside, something that only became visible because he let them in and kept talking. The case against him was eventually dismissed, but the legal fees were not. And the record of the arrest, even without conviction, followed him for years in background checks. You probably think if I had nothing to hide, that outcome was still better than being uncooperative. Most people think that, and most people are wrong. Here is what the law actually gives you in that moment. The Fifth Amendment to the United States Constitution protects you from being compelled to be a witness against yourself. That protection does not begin after you are arrested. It begins the moment a government agent is asking you questions that could be used to incriminate you, and it begins whether you know it or not. James Duane, a law professor at Regent University, spent years studying federal criminal cases to find even one example of a person whose voluntary statement to police made before arrest, truthfully made, cooperatively actually helped them avoid prosecution. He could not find one, not one documented case where talking freely without a lawyer improved the outcome. The reason is a mechanism most people do not know exists. Under federal rule of evidence 801 days 2, anything you say to a law enforcement officer is admissible against you as a party admission. Even if it is true, even if it is taken out of context, even if you said it trying to help, the prosecution does not need to prove you were lying. They only need to prove you said it. You cannot later say, that is not what I meant, and have that correction carry the same legal weight as the original statement. The first thing out of your mouth is what travels through the system. So here's exactly what to say when police arrive because someone called on you. You step outside if you can never invite them in. You say, "Officer, I am happy to cooperate." You ask, "Am I free to go?" If the answer is yes, you say, "I am not going to answer questions without speaking to an attorney first." If the answer is no, you say, "I am invoking my right to remain silent and my right to an attorney." That is it. Those words, exactly those. Not because you are guilty, not because you are hiding something, because the alternative talking has a documented, measurable, consistent record of making things worse. Even for innocent people, especially for innocent people who think their innocence is obvious. Now let's talk about something that surprises almost everyone who hears it for the first time. In 23 US states, if police respond to a domestic disturbance call and they observe any physical sign consistent with a struggle, a scratch, a red mark, anything, they are required by mandatory arrest statutes to arrest someone. The decision is no longer theirs to make, it is no longer yours to influence. The caller does not control it. The alleged victim does not control it. Even if both people in the house tell the officers nothing happened and beg them to leave, an arrest must be made. These laws were passed after decades of research showed that in domestic violence situations, victims often recanted under pressure. The laws were designed to protect people who felt unable to protect themselves. They also mean that a person who is defending themselves, who has a mark on their arm from grabbing a wrist to stop being hit, can be arrested as the aggressor, while the person who initiated the violence watches from the couch. This happened to a woman in Washington State in 2017, name withheld from public record, but documented in legal advocacy reports. She called a friend during an argument. The friend called 911. When officers arrived, both people had visible marks. Under the state's mandatory arrest statute, officers made a judgment call about who was the primary aggressor. They arrested her. The charges were eventually dropped. The protective order that was automatically filed against her automatically as part of the arrest process meant she could not return to her own home for 3 weeks while the case was pending. Her children were inside that home. There was no conviction, but there was no taking it back either. The mandatory arrest statute in Washington is codified under RCW 10.31.100. It applies in every domestic call where physical injury is visible or alleged. You should know that before you call anyone. Now here is the part of this that almost no one has heard. The person who made the call, the one who set all of this in motion, they have almost no legal liability for what happens next. In most states, filing a false police report is a misdemeanor, a fine, maybe a few days in jail, almost never served. But the person they called on their legal exposure is unlimited. A misdemeanor arrest can cost $10,000 to $30,000 in legal fees to defend. A felony charge, even one that is eventually dismissed, can affect housing applications, job offers, and security clearances for years. There is no symmetry here. The caller takes a small risk. The person called on absorbs everything. This asymmetry is not an accident. It is the design, which brings us to what happens when police arrive and you are not a citizen. Most non-citizens in the United States believe that cooperating fully with local police protects them, that being helpful, transparent, and forthcoming will be noted and respected. Here is what they do not know. Since the expansion of the 287G program, a federal program under Section 287G of the Immigration and Nationality Act, local police departments that have entered agreements with Immigration and Customs Enforcement can transfer a detained non-citizen directly into federal immigration proceedings. Your local wellness check becomes an immigration hold. An officer asking, "Do you live here?" becomes the first step in a process that does not end in your neighborhood. As of 2023, over 150 law enforcement agencies across 25 states had active 287G agreements. You probably do not know if your local department is one of them. Most people do not. This is not speculation. In 2018, a woman in Nashville was stopped after a neighbor reported a noise complaint. During the stop, officers determined she was undocumented. She was transferred, she was deported. Her 3 American-born children were left with a family friend. She had lived in the same house for 9 years. A noise complaint. Her neighbor did not know this would happen. She did not know this could happen. If you are not a citizen and police arrive, for any reason, say nothing about your immigration status. Say nothing about where you were born. Invoke your right to remain silent. Contact an immigration attorney before you answer any question. This is not about guilt. This is about a parallel legal system that activates the moment certain words are spoken. There is a gap in this country that almost nobody talks about openly. Police have what is called qualified immunity, a legal doctrine, not in the Constitution, developed through court precedent beginning with Pearson v. Ray in 1967 and significantly expanded in Harlow v. Fitzgerald in 1982 that shields officers from civil lawsuits unless they violated a clearly established right. What that means in practice: if an officer makes an incorrect judgment call that damages your life, a wrongful arrest, a forced entry based on a mistaken address, an escalation that results in injury, your ability to sue is nearly zero unless you can find a prior court case that ruled against that exact type of behavior in nearly identical circumstances. The law on paper says you have rights. The law in practice says those rights are very difficult to enforce after the fact. The protection you think you have when you cooperate and trust the process is not backed by the legal infrastructure most people assume it is. And one more thing, one thing this entire video has been quietly building toward. The person who called the police on you did not necessarily want what happened next. Most callers, neighbors, family members, ex-partners, bystanders, make that call believing police will arrive, calm the situation, talk to both sides, and leave. They do not know about mandatory arrest laws. They do not know about immigration holds. They do not know that a wellness check can become a search if the officer sees something through the window that creates exigent circumstances. They pulled a lever and walked away. What the lever was connected to, that is what this video has been about. You cannot control who picks up that phone. You can control what happens in the 60 seconds after the knock. 3 things. Write these down. If police arrive because someone called on you, step outside, do not invite them in, and close the door behind you. An officer needs your consent or a warrant to enter. The moment you invite them in, that protection disappears. If you are asked questions, any questions, say, "I am not answering questions without an attorney." Not, "I have nothing to hide." Not, "I will explain everything." Those sentences have never in documented legal history helped an innocent person in a U.S. criminal proceeding. The 5 words have: if you are detained, do not resist, do not argue, do not perform innocence for the camera. Say your name if required by state law. Say nothing else. Every additional sentence is a sentence that can be used against you in a proceeding you do not yet know is coming. The book I would put in your hands after this is called You Have the Right to Remain Innocent by James Duane. He is a law professor. His lecture on this topic has been watched over 20 million times. The book goes deeper, specifically into how truthful statements made to police become prosecutable admissions under federal evidence rules, and why the Fifth Amendment protection that most people think activates at arrest actually activates the moment a government agent starts asking questions. Chapter 3 alone is worth more than most legal consultations. Find the link in the description, top of the box. One question before you go. If someone called the police on you tonight, right now, and officers showed up at your door in the next 20 minutes, what would you actually do? Not what you think you should do. What would you actually do in the first 60 seconds? Think about that honestly, because most people, when they imagine it, realize the answer is not the one that protects them. The law does not reward cooperation, it records it. If this changed how you see something, there is more. Subscribe.
That's all for this video. For more information, watch these videos.